Thank you for joining us today. Sorry for the delay, and I apologize that we had to move over to a new YouTube link. If you missed the very beginning of our presentation, this is going to be recorded, so you can listen to the beginning if you've missed the first couple of minutes. So we welcome you to come back and listen to that. So, welcome to our presentation entitled Access and Transparency, Records Held at the National Archives. My name is Andrea Matney, and I am the coordinator for the Know Your Records program. Know Your Records provides information on how to access and do research using U.S. federal government records held at the National Archives. During today's live broadcast, I will facilitate the YouTube chat and then the question and answer session at the end of the presentation. From the YouTube webpage, you can chat and ask questions. You can also follow the hyperlinks that are on this webpage, and they will take you to live captioning, the presentation slides, and the event evaluation form. So if I could have my presenters come up. I'm so pleased to have this expert panel during Sunshine Week. And on the screen, we have our presenters, and they're sitting in the order that they will go. I'm so pleased to have this expert panel. And now I am turning the program over to our moderator, Gary M. Stern, National Archives General Counsel, Chief FOIA Officer, and Senior Agency Officer for Privacy. Thank you.
Thank you. Thank you, Andrea. And welcome everyone who's here in our theater and who's streaming online to the National Archives and our panel on access and transparency. This is, as many of you know, Sunshine Week, in which is the time that we celebrate the Freedom of Information Act and openness in government. And frankly, that's the main reason I, just a lawyer, am here with this incredibly distinguished group of archivists as the moderator, because, as Andrea just noted, not only am I the General Counsel, but I am NARA's Chief FOIA Officer, so I kind of oversee the access and openness programs of the National Archives through the FOIA. And of course, here at NARA, we do FOIA, and we love FOIA. But whereas FOIA is often the only way for folks to get access to government records from most other agencies, for us, in some ways, FOIA is just a footnote. As I've often said, the National Archives has been doing access since long before there was even a FOIA. We were created in 1934, and our mission from the beginning was to provide access to records. The FOIA wasn't passed until 1966. And so we already had kind of our core systems in place, and then we've utilized FOIA as necessary. We also like to say access is our middle name. It's the core purpose of an archives. We collect records so we can make them available to all of you as soon as we can. Doesn't mean we can make everything available immediately, but that's the mission, that's the goal, and that's the work of the archivists to review, process, and make available the records. And indeed, if you look us up online and look at our mission statement, look at our strategic plan, you'll see that our first and core goal is to make access happen. So that's really what we are all about. But, you know, given the vastness of our holdings, we have over 4 million cubic feet of paper records. That's, you know, roughly around 12 billion pages of paper. In this building, in our main archives facility in College Park, Maryland, and in 13 presidential libraries, 14 presidential libraries actually, and our regional archives all across the country. We have records everywhere. But we don't just have paper, we have now petabytes of electronic records, including hundreds of millions of emails. We just got, a year ago, at the end of the Obama administration, roughly 500 million emails just from the Obama White House, both under the Presidential Records Act and the Federal Records Act. And then we have just about any and every other medium of records you can imagine: film, tape, photographs, maps, posters, whatever else. Some of these folks can describe all the other types of formats, and we have every type of information in those records, and most of which, as you'll hear, we can make available fairly right off the bat, but some can be highly sensitive with classified national security information, information about nuclear weapons, law enforcement information, other personal privacy information, tax returns, trade secrets, even rocket science stuff that maybe Don will talk about, or Joe. I'm not going to quiz the panel on what exactly they have in each of their domains, but now really I'm here just to set the stage and then pass it on to my esteemed colleagues, and I'm going to let them introduce themselves. You have their basic information up on the screen, but I'm going to start with Martha Murphy.
There I am. Welcome, everyone. I'm happy to be here. I am the Chief of Special Access in FOIA. My team handles Freedom Information Act requests for records in the D.C. area. I'm also the FOIA Public Liaison for Research Services, so if any of you have filed a FOIA and have a question or a complaint, you'd be likely talking to me. I've been at the National Archives since 1991, and I've been working with FOIA since around 1995 in one capacity or another. So we're here to talk about how to get access to our restricted records, but I really wanted to start out with how to get access to our unrestricted records. If you walk away from anything from this presentation, the most important thing to know is you do not need to file a FOIA to get access to most of the records at the National Archives. The vast majority of our files are old, historical, and time erodes all sensitivities. So the vast majority of our holdings are open and available. So how do you know what we have and whether it's sensitive and whether you need to file a FOIA? The best place to start is on our online resources. We have a National Archives catalog that provides descriptions of the series of our holdings. As you may know, in archives generally, we don't describe things at the item level. We're describing series of records. You can also send emails to the unit who has access to the records that you may find online. And I'm going to show you a little bit about our catalog and where you can find that kind of information. If you have a research topic, you're having trouble finding anything online about it, but you think it might be at the National Archives, you can always send an email to inquire@nara.gov. That is our general email box. We have folks who read the emails and try to figure out which unit may have access to the files. We also have something that's fairly new to NARA called the History Hub. It is an online research forum where people can post questions and get answers. Sometimes those answers come from NARA employees who are participating in the hub, but very often they come from your research colleagues. We have lots of very experienced researchers at the National Archives. Sometimes you can post an answer and they might get an answer right from the research community. So I highly recommend checking out History Hub. And of course, you can always visit the National Archives Research Room and then talk to a reference archivist there. So just a little bit about our online resources. I'm going to show you a few, and I know this is kind of small, a few screenshots of our catalog. This item itself is not of the executive branch. This is donated to the donated series that is at the Kennedy Library. But regardless, what you will see here is the creator, the date parameters, and basic information about the series itself. There is a scope and content notes, which will give you some idea of the type of records, topic-wise, that you might find in there. But what I really want to point out to you for the purposes of today's presentation is the access restriction field. That's where you're going to know whether the records are unrestricted, open and available, come on in, ask for copies, good to go, or whether there may be a restriction you need to be aware of. If it says restricted partly, like this one does, you should be able to get access to the series itself. However, when you're looking through the boxes, you may find that there are withdrawal forms documenting documents that have been withdrawn for some sensitivity. That's why it's restricted partly, but available. If it said restricted fully, that would be your note or your clue that you're going to have to file a FOIA to have access to the files. The use restriction is something else. I think it confuses people sometimes. That's not about whether we can serve the records to you. That's about how you can use the records once you have access to them. The biggest use restriction that people will encounter is copyright. Now, records created by federal agencies are not subject to copyright. They're in the public domain. But we do sometimes acquire publications or donations from folks where there may be copyrighted information. If so, we'll try to let you know in our catalog. Here you'll see contacts. The contacts is the unit within the National Archives who has custody of those files and who can help you to gain access to them. As you probably know, we have this building, we have College Park, we have field units throughout the country, east to west, north to south, and of course all of our presidential libraries. So there are a lot of different organizations who have custody of records. You will see them here. So, a lot of people will ask us, well, why would records of the National Archives be restricted? You must just have old records, right? We do actually have records that are as recent as 15 years ago. Generally, agencies wait until there is no longer a business need before they transfer records to us, but some of them come quite early. We also have records that retain their sensitivity for a long period of time. Some security classified records might stay classified for more than 50 years. Also, law enforcement files might have some sensitive information about sources and the like that can be, say, sensitive for quite some time. NARA is a federal agency. We're subject to the FOIA, which means we need to try to make records available to everyone. But it also means that we recognize that there are certain categories of information that are sensitive and that we need to protect. So, how do we know if records are sensitive? Well, the first step is for the agency that is transferring the records to the National Archives to let us know. So this is how it works. Agencies are at their agencies and they're creating records. Those records are part of series. Those series are scheduled. Most series are temporary and never come here, but about 5% are considered permanently valuable, and they come to what we like to refer to as heaven here at the National Archives. Before they are transferred to us, the agency has to do a legal document transferring legal custody to the National Archives. It's called a transfer record. And there is a field that allows the agency to let NARA know that at the time of transfer, there might be areas where there are sensitivities. It is connected to the provisions in the FOIA for restrictions. They're referred to as the B provisions. And there's simply a drop-down that they can let us know. So our accessioning staff, the people who bring in these records and put them on the shelf, will document that in our holdings management system, which is our internal control system that tells us what box is on what shelf. It has a field for access restrictions, so it'll get documented right from the very beginning. And then when the time comes when an archivist, a processing archivist, does the work to rebox, describe them further, and get that information into the catalog, again, that information is transferred in so that the public has access. So we now have a means by which agency information can be captured from the minute the records come in the door, and we can let the public know as soon as possible what the current access status is. So that's basically how it works. We also do a physical label on the box, just so we have a visual cue as well. So why are the records restricted? As Gary referred to, in the Freedom of Information Act, there are 9 reasons why records can be restricted. Some of those are very rarely used by the National Archives. I just wanted to sort of go through the ones that are most commonly used by the National Archives, or records that we will see with these kind of restrictions. The first one is security classification. A lot of folks assume that if it says restricted in our catalog, it must be classified. That's not necessarily the case. There are 9 reasons, and security classification is only one of those. It is the first one, B1. So Don is going to talk a little bit more about how we administer the review and release of classified documents, but just for now, that is one of the categories. Another is statutory withholdings. There is a provision in the Freedom of Information Act that allows for withholdings for other statutes that have been passed by Congress. So we're going to talk about tax information, grand jury information, wiretap. There's a lot of them. Most sort of fall away before the records come to the National Archives, but there are things that we are looking for. A big one for us is personal privacy information. So that includes what's referred to as PII, or personally identifiable information. That's the kind of data that people can use to steal your identity. Social Security number is the big one. Also, home address, mother's maiden name, date of birth, place of birth, those types of things. So we're concerned if we have records that are full of PII. But that's not the only privacy concern. There's also what I like to refer to as sort of contextual privacy, actually information about you that you have a right to keep private, your medical information. If you're ever accused or investigated for an illegal activity and you're never charged, you're never indicted, you never go to trial, you have a high level of personal privacy interest in that information. So those are the type of things why we have to sit with law enforcement records and actually read them all the way through, understand the context, know whether the person actually went to trial or not. Those are the type of records we're concerned about. Generally, that's going to be in that last category, law enforcement records, but we also find it in files of medical, we find medical information in some regulatory agencies and things like that. So we are looking everywhere, but generally we're going to find that in law enforcement records. In addition, in law enforcement records, we're also looking for identities of sources and personal privacy. Those are the two biggies, and there's a few other interests as well. Less common, we do sometimes find business proprietary information, bank examination records, or information regarding wells. I know that seems kind of odd. It's the last provision of the FOIA. More likely to find that out in our fields where they have Bureau of Land Management records, but it is something that once in a blue moon will come up. So you've gone in our catalog, you found something that's interesting, or maybe you've talked to one of our reference archivists, you've figured out that, this is restricted, I'm going to need to file a FOIA. So how do you do that? It's really pretty simple. All we need is something in writing. So it can be come to us through the postal mail, which we get a few still, faxes, not so many anymore, or email. Most of our requests are coming to us via email now. You can also use the FOIA online portal, which I believe, Joe, are you going to discuss that a little bit? It's something new, but there is a FOIA online portal as well. But as long as we have it in writing, what we're going to be looking for is as much detail as you can provide us about what records you're actually interested in to help us to figure out what it is that you need. So I do want to just show you this webpage, and this is something that my team has put together for the DC area. But the one thing you may want to look at is we have a nice little video about how to file a FOIA, and it gives you all kinds of great information that hopefully will smooth the way. The more information you can give us, the better off, because we want to make sure we're all clear about what it is that you want. We can narrow it down as much as possible. So I just brought that up just so because I want to urge you to take a peek. It's a fun little video. It's short, I promise. So what can you expect once you file your FOIA? Well, within 20 days, you're going to hear from us. We're going to give you a FOIA tracking number. We're going to have a statement in the letter or the correspondence or email about whether the topic you're interested in, whether we found records that are responsive to your request. If we find that there's nothing sensitive in the files that we found, you'll have instructions about how to access the records, either by coming here or requesting copies. If we realize that these files actually do require an in-depth review, you will get an estimate of how much time it's going to take us to complete review of your FOIA. You're going to be notified when the FOIA review is complete. If any records are released to you, which they likely will be, you will be given the options to either come on in and view them here in one of our research facilities, in which case it would have cost you nothing to go through this process. If you would like to order copies, we will provide you with a quote for the cost of reproduction. If the records are restricted in any way, you're going to be notified of that fact. If we have to withdraw an entire document, when you see the records, you will see a withdrawal form in the file. If we can release a portion of the file, under the law, we are required to release a portion. In those cases, we will have redacted the document, and you will see the redactions. We will also document on either the withdrawal form or the redaction which FOIA provision was relevant to that redaction. I just wanted to show you an example of a redacted document. This is a document that was reviewed. It was an FBI document. And as you can see to the right, it says FOIA B7D. That means that that information that we took out was the identity of a confidential source. But this is what it might look like. So our final response letter is going to have this type of information. We're going to list what was released in full and what was withheld, if anything. And very often we're telling you it was 500 pages requested, 400 pages were released in full, 100 pages had required redaction. We're going to explain the FOIA provision under which the records were withheld in plain language. So we're not going to just tell you we had to hold 12 pages for B7D. We're going to explain to you that that is information which gives you the identity of a confidential source so that you understand what you're looking at. We're going to provide you with appeal rights if any information has been withheld. We're going to also provide you with contact information for the FOIA public liaison in case you have a question or are dissatisfied with how your FOIA was administered in some way. And we are also going to provide you with contact information for the Office of Government Information Services. As many of you know, OGIS is an organization that is within the National Archives, but they serve as an ombudsman for the entire federal government for FOIA complaints. So the way it generally works is a FOIA comes out. If you're unhappy, you file an administrative appeal. If you do not like the response to the administrative appeal, your legal recourse at that point is to sue. But you can also contact OGIS and see whether they can facilitate a resolution to your concern free of cost. So there's really no harm in contacting OGIS first, and I would urge everyone to take advantage of that.
And I'll just pop in to say, also you can contact the FOIA Public Liaison, and Martha is one,
Right.
John Laster is one, and I'm one as well, another one of my titles. So we try to give you as many opportunities to try to work it out and understand what, why something's being withheld, and try to work with us to resolve it before you decide if you want to and feel you need to file a lawsuit.
Or even before the appeal. I very often interact with researchers very early in the process. And it really works great if we can get it done sooner. The sooner the better. So I'm going to pass it on to Don McElwain, who's going to discuss how we administer review and release of classified documents.
Thanks, Martha. As noted on the little bio there, I'm Don McElwain. I am in charge of the Classified FOIA and Mandatory Declassification Review Unit in the National Declassification Center. So for security classified records in the Washington area that are from executive branch agencies, my office handles FOIA requests, mandatory declassification review requests, and other questions from researchers regarding classified information. We work very closely with Martha's unit. Her unit generally logs in the initial FOIA requests, performs the triage, and sometimes we'll have a back and forth because her folks have expertise in certain areas, mainly privacy and law enforcement, where with nuclear information and classified, my folks may know who to reach out to. So I think one point I'd like to start with at the beginning, it's a team effort, and we're all on the same team wanting to release as much as we can and only have to protect what we absolutely must under the law or in the case of classified under the executive order. So declassification of records in the National Declassification Center is going to be the title of my talk. And Executive Order 13526 is the order that governs the classification, safeguarding, and declassification of national security information. It was signed by President Obama in December of 2009, and it is what governs classification. An organization that's administratively part of the National Archives, the Information Security Oversight Office is tasked with overall policy responsibility for the entire federal government of classifying, safeguarding, and declassifying. So every agency that classifies in some ways gets its marching orders from ISOO. I'm going to talk about a couple of provisions of the executive order. Section 3.3 and 3.4 deal with automatic and systematic declassification. Section 3.5 deals with mandatory declassification. And Section 3.7 deals with the National Declassification Center. Prior to this executive order, there was no centralized facility or coordinator for declassifying government records that had been accessioned to the National Archives. So in 2009, the NDC was stood up, and we'll talk a little bit about that. Section 3.3 and 3.4 are what requires permanently valuable historical records to be reviewed for declassification by the time they're 25 years old. And so we'll talk a little bit more about automatic declassification. When the agencies that created the records or have legal custody of the records need to review the records, as I said, at 25 years, they can do one of four things, and this is usually done at the document level. They may exempt the record from automatic declassification, and there's 9 reasons spelled out which they can. For example, human intelligence sources and methods, weapons of mass destruction. Those are probably the 2 biggest ones. Information where, if it was disclosed, could negatively reflect the foreign relations of the United States. They may refer that document to another agency or agencies. So if I'm, pick an agency that has classified records, if I'm the Army and I'm reviewing my records because I want to transfer them to the National Archives, and they're 23 years old and they're permanent, but I don't have any continuing ability to hold that record as classified, but I notice that I think these documents need to be seen by Navy, then what you do is you refer that to Navy. The third option, and one that we like to see by the time the records get here to NARA, is you may declassify the records. That's a great thing. Declassification does not necessarily equal access. As Martha pointed out, national security information is only one of 9 reasons why a record still may be restricted. But if you declassify the record, then other restrictions may still apply. And we rely on the agencies to tell us what restrictions are in the records before they come to the National Archives. And fourth, you may exclude that document from automatic declassification. This is a little bit of a term of art. Exclusion is almost the same as a referral, but it's identifying this document as something that may contain restricted data under the Atomic Energy Act. So if it relates to nuclear matters, it's classified, but it may be not classified or not subject to automatic declassification. So you've done your review, you've identified those records that are exempted, excluded, or referred, you've declassified the rest, and you send them to the National Archives. And that's what happens there. So you've gone through, you've looked at the catalog that Martha was talking about, or you're reviewing a body of records, and you come across that withdrawn items notice that, again, Martha set me up really well here, was talking about, and you say, gosh, restricted fully, national security classified, or on the withdrawal sheet it says, this document was withdrawn because it's still classified. I have a couple of avenues in which to request declassification, another review of that record. And when you're requesting this declassification, instead of reviewing pass-fail at the document level, the person doing the review is going to be required to review the document line by line, word by word, and segregate out that stuff that still has to stay classified. And that's, as Martha mentioned, the Freedom of Information Act and the mandatory declassification review provision, which is Section 3.5 of Executive Order 13526. The Freedom of Information Act, as we've already pointed out, is a statute. What will happen? Your request will be received. As Martha pointed out, it'll get logged in. You'll be assigned a tracking number. If it's for classified, my office will send that initial reply. We will do a preliminary review of that document, and we will identify any agency that may need to see that. And that includes possibly the agency that exempted the document, or any agencies that we believe may have an interest or sensitivity in that record. We will prepare the document to go out unless we can deal with it in-house. And it's important to realize NARA has no original classification authority. So it's very limited in what we can do in-house to review documents and declassify documents. Everything that we can do is granted us in an agreement by the agency that owns that information. And we do have some agencies that will allow us, in certain cases, to act on their behalf. But otherwise, the document or documents have to go out to these agencies. They're sent via classified channels. The agencies review the documents. They will give us one of three decisions. They will declassify the document in full, which we like. They will provide redaction instructions, which then we will apply. We'll coordinate the redactions so that every agency that has a valid redaction, we're not inadvertently releasing something we shouldn't, or they can deny the document in full. As Martha pointed out, you can appeal these decisions, because we're going to send you back correspondence saying, you know, the Department of State released 2 documents totaling 10 pages in full. The Central Intelligence Agency released 1 document in part with portions redacted, and then we'll provide you appeal instructions. If you're going the FOIA route, you also have the option to contact OGIS. You also have the option to contact our FOIA public liaison, which for the Washington area is also Martha. If you want to informally contact me, I'm happy to work with researchers. One of our goals in the NDC is to solve things as much as possible informally and at the lowest possible level. Ultimately, though, if you've exhausted all your appeals and you're still not happy, you can sue. I think I've already gone through this, haven't I? Step ahead of myself. I wanted to point out, Martha mentioned the 9 FOIA exemptions. There they are again. I just want to highlight FOIA B1, which is national security information. I'm not going to read this to you, but that's what it says about classified information and why it can be held under the FOIA. And again, as I mentioned, we don't have the ability to declassify on our own. We rely on agencies providing us guidance, working with agencies, and most of the time we still have to send copies out to the agency to review.
And Don, let me just highlight that. That's an important thing, because that's only the case in the National Archives with respect to classified information. All the records that are in the National Archives belong to the National Archives. We own them. Martha described that they're created mostly by agencies and transferred to us, and they're legally transferred into our both physical and legal custody. With respect to making the decision to disclose, we make that decision in basically every instance except with respect to classified. Because of the way the executive order and the laws are set up, the agencies that created them retain the exclusive authority to declassify that information in virtually all aspects. And so that's why we created or helped, and asked for a National Declassification Center, which we oversee, but agency officials work in our buildings to do the declassification review of those records, as opposed to, if it's law enforcement or privacy or anything else, NARA officials, NARA archivists, NARA staff are doing that review and making those decisions.
Yeah, that's a good thing to point out. We wish we could just unilaterally review and declassify other agencies' interests, but because we don't, in the NDC anyway, we really try to work collaboratively and cooperatively with the agencies, and sometimes we may not see eye to eye with the agencies. And again, be aware that NARA is going to be negotiating on your behalf when we have a disagreement with an agency on, really, that's still classified? and I've had conversations with my colleagues at other agencies regarding that. And at the end of the day, what we want to have consensus. So mandatory declassification review is a second way to ask for declassification. And it's spelled out in Section 3.5 of the Executive Order. And what's nice about the mandatory declassification review provision, and John will be touching on some of this a little bit later, it's not a law, but it allows for records and materials that can't be requested under the Freedom of Information Act, allows an avenue to request a declassification review. In many cases, if you know with specificity what you want reviewed, for example, if you came to me with copies of 3 withdrawal sheets and asked me how should I request these to be reviewed, the mandatory declassification review provision is most likely going to be a more efficient way of requesting access and declassification when you've got very specific information and you know exactly what document or a handful of documents you want reviewed. Processing a FOIA request is very similar. We're going to, in-process it. FOIA requests come to us in the same way that, or mandatories come to us in the same way as FOIAs. In the way we process it in the NDC, we really don't make a distinction. But as you can see, it's the same thing. The difference is the last resort appeal. With a mandatory, you don't have the right of a judicial review. What happens is you can appeal to the Interagency Security Classification Appeals Panel, or the ICECAP, and that is a high-level panel of folks from different government agencies, and they will consider your appeal, and they also operate on consensus. So there are trade-offs. Again, ICECAP appeals don't cost anything. Suing in court, my understanding, could run up a legal bill. Last, I wanted to touch base briefly on the National Declassification Center. As I mentioned, this was set up to do a number of things. It was to facilitate training across the whole declassification community. It was to look at processes and procedures for improving the process of reviewing and making available declassified archival records. And it was to come up with ways to improve the referral process and to look at other new processes for declassifying records. Again, the National Declassification Center, as part of its job of looking at new ways to facilitate review and release of material, one of the things we did was create indexing on demand. So if you go to that catalog entry that Martha pointed out earlier, and it says the access restriction is, it's closed, you can then go to our website, and I've got the link there to our list of record series that have been through all of the declassification review except for the final separation of the still classified materials from the declassified materials, and request that that particular series be moved to the top of the list for final processing. This is one way we invite you guys, the members of the public, to help us prioritize which series of records that have gone through declassification should we process for release and getting out to the open shelf first. So I would encourage you to take a look at that and help you guys determine what are the most interesting records that we can release and get out to the open shelf. If you want more information, there's my contact information, and I would encourage you, if you've got questions on declassification of federal records in the Washington area, to please contact me. Now, I'll turn it over to my colleague, John Laster.
Thank you very much, Don. So apparently I have the ability to break technology just by sitting here, so I get to balance a microphone as well as the clicker. My name is John Laster. I am the director of the Presidential Materials Division here at the National Archives. I've been with the agency for 21 years, and during that time I have worked entirely with access to records, whether that was at the George H.W. Bush Library, where I started out as a processing archivist, or in my career here in the D.C. area, where I specialized in access to presidential materials from all of our libraries. So I want to talk about two different things. What is available and what you do to get access to presidential materials that are not yet available. And again, Martha and Don did a great job of setting me up. I don't have a slide that particularly talks about what we have open, but I did want to go through it very quickly. As Martha mentioned, there's the National Archives catalog. The presidential libraries are part of NARA, and as such, we use the National Archives catalog to also make determinations or to present researchers with information about what records are open. In fact, Martha chose one of the first was for the Kennedy Library. So that information is in there, and you can get a sense at a high level of what's available or not. Also, the libraries have their own independent websites that you can go to get additional information about what's available to the public. And I wanted to kind of break down a little bit about how much material is available. So there are basically 4 tiers in presidential libraries, and obviously the older they are, the more that's open. So material Hoover through Eisenhower, more than 90% of the material has been reviewed and is open and available to the public. Kennedy through Carter, the second tier, is around 60 to 75% of their material has been reviewed and is available. Now, you may take a library like Kennedy and say, well, why isn't that farther along? One of the things you need to keep in mind with presidential libraries has a very active donation collection policy for papers not only of the president but of his associates, et cetera. For example, the Kennedy Library just received a very large collection of Edward Kennedy papers, which took a much higher number that they had processed and dropped it down. Reagan and George H.W. Bush are in the 50% range, and then Clinton and Obama are at about 10% or under being processed at this point. So there are some differences, although you will see a lot of similarities as we go through this to what Martha and Don have talked about on the federal side. There are some differences in how we provide access to presidential materials. For the federal, all under the executive branch, but for the federal records of the agencies and departments, they're all governed by the Federal Records Act. They're all subject to FOIA. It's one law. It's consistent across the board. For presidential materials, there are 3 separate laws that govern access to our material. There are donated materials. One of the things I always find interesting is that people often do not realize that from George Washington through Jimmy Carter, with one exception, the papers of the president belonged to the president and could be done with whatever they wanted. Now, early on, this meant a not complete collection of most 18th and 19th century presidents. Things have been pieced together. Some presidents had more foresight into the historical value. For example, Adams and John Quincy Adams' papers are at the Massachusetts Historical Society. Many others are just lost, scattered. Some were actually destroyed, not inadvertently, but advertently destroyed for various reasons. Outside of the National Archives, the largest collection or holding institution for presidential papers is the Library of Congress, and they hold a good chunk of the 19th century president's papers. We, the National Archives, became involved in the papers of presidents starting in 1939. Franklin Delano Roosevelt was a huge fan of the National Archives and thought it would be great to donate his papers to the National Archives, and he did that in 1939. From that time forward, all other presidents up through Carter, with again the exception that I'll talk about an exception, donated their papers. And then Herbert Hoover thought this is a great plan as well, and so he retroactively donated his papers. So those first sets of papers that we have, the majority are under this have been donated to the National Archives with access restrictions. The second set, the exception to everything that constantly causes a longer presentation, say, or more adds complexity there, is Nixon material, which was seized during Watergate, and I'll talk a little bit more about that. There's a specific law that just deals with Nixon material. And then finally, the papers of Ronald Reagan Ford are governed by the Presidential Records Act, and this is a direct result of Nixon's material being seized. There was an idea that there was a need to study this personal ownership of presidential records, or as well as the records of members of Congress and judges. Coming out of that, Congress decided to pass the Presidential Records Act. It was signed into law by Jimmy Carter in 1978 and took effect with the next president, Ronald Reagan, in 1981, making these papers the property of the government and making certain changes to them. So just a quick overview. Donated materials are not subject to FOIA, which Don alluded to. And so the rule for gaining access to them is basically the libraries systematically review this material, and when they have, researchers can have access to it. The libraries that are governed by deed of gifts that have donated materials are very conscientious of working with the public, and as much as they can will focus their research on or focus their processing on topics that are of interest to researchers. As Don also alluded to, the material, the one way you can actually request material through a means is for classified material in the donated collection. So just like with the federal records, if you know that there is a classified record, you can request under a mandatory declassification review that material be reviewed. And the process works exactly like Don was talking about. PREMPA is the same way, basically, systematic review, not subject to FOIA, but you can file an MDR, and PREMPA is shorthand for the Presidential Materials Preservations Recordings Act. Presidential Recordings and Materials Preservations Act. Sorry, the recordings were very important with Nixon. So it's basically the same as donated as far as gaining access to it. And then finally, you have the presidential records, and the big change there was that this material is subject to FOIA. There are a couple of other changes as well that I'll talk about shortly, but making these records subject to FOIA was the biggest change in this coming out of the Presidential Records Act. There are a lot of similarities between or among the three, the deed of gift, Nixon's papers under PREMPA, and the Presidential Record Act libraries, which are Reagan, Ford again. Very similar also to FOIA exemptions and NARA's general restrictions, which Chris will talk a little bit about. National security information, of course, personal privacy, everything that Martha talked about, even in a deed of gift world, that material is generally withheld. Law enforcement information, grand jury information. One of the things we have in our records that don't show up that much in federal records are records related to protection of the president, and that's another thing we will close often. But those are similarities along that run throughout, whether it's donated material, Nixon material, or material governed by the Presidential Records Act. Nixon does have and I didn't include a slide here, I'm sorry. Nixon is a little interesting because there is a category of records that normally may be closed under exemption, but definitely are not closed, which are records related to abuses of governmental powers. The PREMPA specifically states that this material is in fact open and should be open. This is material that sometimes, if it were in federal records or other presidential records, would not in fact be released immediately to the public.
And just note that abuse of governmental power relates specifically to the Watergate affair. It's Watergate. Yes. I mean, that statute seized those personal papers in part because they were potentially evidence in the criminal trials that were ongoing back in the mid-'70s on former Nixon administration officials and relating to the Watergate affair, which then in the law they refer to as abuse of governmental powers.
So the last thing I want to talk about is some of the differences with the Presidential Records Act. So Reagan Ford, again, one of the large things is that it is subject to FOIA, so anyone can come in and request access to this material. But there is one exemption that does not apply, which is the B5 exemption related to deliberative material. Now, you will notice that Martha did not mention this either because the National Archives and federal records almost never, and if Martha had her way, would never apply this one exemption. So it is very, very rarely used. And under the Presidential Records Act, Congress just said you can't use it anyway. But they did something else. They gave the president the option of, for a 12-year period, invoking 6 other restrictive categories beyond the 8 FOIA exemptions. And 4 of those mirror exactly FOIA exemptions, so they result in no more material being closed. But there are 2 unique ones, one related to appointments to federal office, so whether it's material relating to appointments of the nomination process and appointment of a Supreme Court nominee, or anyone else that the president, the hundreds and hundreds, potentially thousands of people that the president has control over appointing throughout the federal government, that material can be closed for a 12-year period. And then the other is confidential advice between the president and his advisors or among those advisors. Now, this is very similar to that B5 restriction for deliberative process that the National Archives doesn't apply. So it'll often result in this material being closed. But one of the things I mentioned earlier is that these restrictions, these 6 restrictions, 2 of which are unique, only apply for that 12-year period. So it goes away very rapidly, and considering on the federal side we don't get records generally until the 15, 25, 30-year mark, those sensitivities have gone away on the federal side, and they can only be held for a limited time on the presidential side. So there is worth noting that while presidential records are subject to FOIA, there is a 5-year basically waiting period. From 5 years after the end of the administration, the public cannot request, either through FOIA or a mandatory declassification review, access to records. I believe when Congress came up with this and put it in law, they just assumed we would be finished processing with everything in 5 years. We don't get anywhere close. But it gives us time. It actually is beneficial. It gives us the time to help gain intellectual control of the material to a level that we can respond to FOIA requests more effectively. So it is actually a very useful 5-year waiting period for us, although researchers don't necessarily agree. Again, for the 5 to 12-year period, you have where the FOIA exemptions apply, as well as the PRA restrictions. And then in the 12-year mark and beyond, it is just FOIA exemptions that apply. There's one other kind of little quirk about presidential materials or presidential records governed by the PRA, and that is that we are required by law to notify the representatives of the former and incumbent president of our intent to release any material. So it's written into the law, 60 working days. The representatives of the former and incumbent have an opportunity to review, if they so choose, material and determine whether they're going to claim executive privilege. After that time, if they've not claimed executive privilege, the material has been released. This has only happened one time in the Reagan administration, and it was approximately 30 pages that were withheld, actually 60, but many of the documents were duplicative, so it's 30 or so original pages. So if you have any other questions, there are 2 places to go, 3 places. The National Archives catalog. Also, I have the address for the presidential libraries. If you go to the archives.gov/presidential libraries, you can find the contact information for all 14 presidential libraries. They have much more knowledge than I do at a more granular level and would be happy to talk to you. You can also reach out to me. I'm happy to point you in the right direction or answer any general questions. And as Gary points out, I'm also the FOIA liaison for the Presidential Library System. So with that, I want to turn it over to Chris Wilhelm, who gets to talk about the world of congressional records.
Thank you, John. I'm clearly not magnetic enough to break my microphone. So. I'm Chris Wilhelm. I've been an archivist in the Center for Legislative Archives since 1992. In all that time, I've never found a document to withhold because it relates to wells. I'm still looking. Thank you. It's important to remember that the legislative branch is more than the House and the Senate. It's also, I knew this would not work for me. There we go. Just like on Jeopardy, it's always the guy. It's also legislative support agencies like the Government Accountability Office, the Government Publishing Office, the Congressional Budget Office, and legislative branch commissions like the 9/11 Commission. That said, most of the records in my office are House and Senate committee records. Now, these committee, agency, and commission records are not subject to FOIA, but that does not mean they're inaccessible. Now, because House and Senate records are not federal records as defined by the Federal Records Act, that means NARA never owns them. And because they remain in the legal custody of each chamber, the House and the Senate can make their own access rules. Briefly, those rules are unpublished records of the House may be requested when they're 30 years old, unpublished records of the Senate when they're 20 years old, investigative records of each chamber may be closed for 50 years, and records of executive nominations are closed for 50 years even if the nominee is dead. Now, legislative support agencies and commissions are federal records under the Federal Records Act, and that means that they are appraised, scheduled, and accessioned into NARA's legal custody. However, they're still a legislative branch, so they're not subject to FOIA. But that doesn't mean you can't request them. If there are any creator-imposed restrictions on those records, we'll let you know that, so just ask us. Now, every modern record that we provide to researchers, we have to screen before we can release it. And that's because, like their executive and presidential counterparts, legislative branch records may contain sensitivities that we have to withhold. Now, since we can't use FOIA as the withholding authority, we use NARA's general restrictions. And these are federal regulations that mirror the FOIA exemptions, including the Wells one. Now, screening is an incredibly labor-intensive task, so if you can please give us as much lead time as you possibly can, so we have a chance to screen these records before you need to see them. Now, for classified records, the mandatory declassification provisions of the executive order work just as Don explained, and that's because the classified information comes from the executive branch, and they control the declassification process. Now, please feel free to email us or send a carrier pigeon with your records request or to speak to our reference staff about your research topic. We also have a website that includes these access rules, as well as links to descriptions in NARA's catalog and other reference tools. And now the always appealing Joe Scanlon. Yeah.
Nice feeling. I like that. Hi, I'm Joe Scanlon. I'm glad you guys are here. I'm also glad to be up here. I've been with the National Archives for a little over 25 years. 24 of them have always been dealing with some form of access. Cut my teeth on old D-Class. Don used to be my boss. And then I moved over to Special Access, in which Martha was my boss. Now Gary is my boss. Okay, so we also have this thing called operational records. And the question is, what the heck's an operational record? So if you were to submit a FOIA to any of the other federal agencies, they're going to go search for their records, because that's what they are. But when the way our agency works is all the work these people do, they are creating records that are the National Archives records. Those are also subject to FOIA. That's where my office comes into play. And just like Martha's slide, which she copied from me, just to let you know,
Absolutely.
the request has to be in writing. Now, writing it doesn't have to be pen and ink. It can be email. We don't take voice messages or anything like that. We'll take fax requests, which we do on occasionally still get.
Yesterday we just got one.
We did, yes. But we also use a product called FOIA Online. It's also just recently changed its URL, so it's now foiaonline.gov. But if you have any links to the old one, it's still there. There's also something that has just recently been stood up, and that was from the Department of Justice and the Office of Management and Budget, and that is the National FOIA Portal. You can go to foia.gov. If you go there and then type in National Archives in the agency search page, you will find all of the offices that are in the National Archives that have records that are subject to FOIA at this site. So they're all there, except for Chris. Her records are not subject to FOIA. For the presidential libraries, only those agencies or those libraries that are under the Presidential Records Act. Again, where was I? Okay, so there are multiple ways to submit your FOIA to us. One of those is also just email. We receive a lot of those, and that's at foia@nara.gov. If you are not sure what office or what component in the agency should receive your FOIA request, please feel free to send it to foia@nara.gov. Myself and 2 other archivists are the ones who look over that. We've been here long enough to understand where the FOIA request should go, and we will send it on to that appropriate office. We will also inform you that we have received your request, and we are sending it on to that office. It's because I sat next to you, I know. Okay, so our process is just like everyone else's process, and I'm actually going to clip through this rather quickly now. Just like everyone else, we have to log it in. My office logs it into 2 systems. One's a database, and one is FOIA Online. We have 20 days in which to respond. That's what the statute said, 20 working days in which to respond. If we can't get to you within those 20 days, we will send you a request for an extension. That gives us another 10 working days in which to. We hope to get those accomplished. Sadly, due to the massive influx of requests, that has been slipping.
Although, I'd like to note, the goal of the agency is 80% within 20 working days, and we meet it as an agency, and we meet it with respect to operational records. So the majority of requests are responded to on time, but in certain particular places we have backlogs, particularly if it's classified and we have to refer them to other agencies. Presidential records, generally because of that review process and the sensitivity and the screening process, those that we might have some delays and do have some backlogs, but overall, in the massive number of requests we get, we're able to respond to the vast majority of them within the 20 working days.
That's correct. We will respond to you in writing, either by, if you don't give us your email account, we will write to you a letter. But otherwise, we try and communicate with email. It's faster. It just is. There's 3 determinations you'll get, and that's across the board for all of us. That's a total grant, a partial grant in which we have to redact part of your document, or denial. We don't tend to give many denials, at least what I would call a true denial. There's always I'm sorry, we don't have any records. That is a denial of sorts, but that's because you've asked for your birth certificate, and the National Archives doesn't have birth certificates. That's a state record. There is one aspect in which people are very confused, and that's the fees at the National Archives. And they ask, why do we charge? Because under the FOIA, I can ask for a fee waiver. And I have it down here as the 2 parts. It depends. What are you looking for? If you're asking for an operational record, like how Chris Wilhelm decided to reorganize a certain congressional office. I know that's kind of a bad made-up version, but if she comes back to me and gives me 1,000 pages of material, and you come up with some really good reason as to why you need a fee waiver, I can grant that. But if you go and ask John or Martha or Don for the records of the Office of Secretary of Defense, those are accessioned historical records. We are bound by our statute in which we will charge you 80 cents a page. But we always give you the chance to just come in, look at the records yourself, make photocopies in our research room for 25 cents a page, or bring your camera and take pictures of it. It's just as, or your own scanner if you can. It's kind of unique, but that's the aspect of, that's one of the unique things about the National Archives. Our goal is to try and give you the records, or at least get you the access, but we sometimes do have to charge. So everyone else mentioned about the Office of Government Information Services. As you can see by the slide, it was stood up in 2007. It started its operations in 2009. Well, it was created, I'm sorry, in 2007, stood up in 2009. And it assists both the FOIA requesters and the federal agencies. The goal is for them to help. They're the ombudsman, they're the middleman, and they're meant to reach out to both sides in order to negotiate an equitable outcome is the best way. It doesn't always work that way, but they try very, very hard. They're a great resource to understand the FOIA process. You should be able to reach out to them before if you go to litigation. Sadly, if you go to litigation, you've lost the opportunity to reach out to OGIS. I do recommend that you go to their website. They have come out with a whole bunch of new exciting. They have a blog that they are constantly mentioning new and updated things that are happening in the FOIA world. And just yesterday, the director, Alina Simo, who used to be my boss, gave her testimony before the Senate Judiciary Committee. So go to that website and the Senate Judiciary Committee's website and go listen to her talk. It's actually quite riveting. I find it riveting. But then again, I'm a bit of a FOIA geek, I think, just like everyone else up here.
Except Chris.
Except for Chris. There's a joke, and I'm not going to do it. Okay. So if you don't like the answers of anyone to this side of me, to my left side, you can appeal. And for every one of those appeals, the appellate authority at the National Archives is our deputy archivist, which is currently Deb Wall. And for each one of these situations, you have 90 calendar days, which is different from 90 working days, just to understand the distinction. 90 calendar days in which to write to her, or you may also submit it to her through FOIA at NARA.gov. The Office of General Counsel actually helps staff up the appellate process for the deputy archivist. Just like in any FOIAs, they can be through email or they can be in fax. If you happen to submit your FOIA to my office under FOIA Online, and it's for our operational records, you may also submit an appeal through that same process through FOIA Online. There's something that has been mentioned a couple of times about the difference between the appellate outcomes of both a FOIA and an MDR. They all still state, if you don't like the answer that Deb gives you or the deputy archivist gives you for FOIA, your recourse is to file in court. For an MDR, it's to go to the ISCAP, the Interagency Security Classification Appeals Panel. The unique difference between the two of them is that if you have national security information and you're going to appeal or you're going to litigate, please understand that the judges tend to give deference to the agencies whose information it is. They don't have time to become an expert in in human sources or weapons of mass destruction or what is a state-of-the-art technology with regards to the Abrams tank or something like that. Under the MDR appeal process, and you go to ISCAP is filled with individuals who do understand that information. And it's a unique body in which there is lots of deliberation, and which is why they tend to have the panel itself has a higher rate of release, very little affirm. It tends to be about 1/3 all the way around as history has shown. One thing ISCAP does not have jurisdiction over is that's restricted data, the nuclear weapons material. While you can submit MDRs and MDR appeals to ISCAP, that panel does not have that authority. You must go to the Department of Energy to seek the adjudication of what is still considered RD or formally restricted data. June 21st, ISCAP is having an MDR forum in one of the presidential rooms upstairs a couple couple floors from 1 to 2:30. So keep looking on the ISOO's webpage. I'm sure they will have some more information about that if you are interested in what that looks like or how that plays out. And then there's appealing accession legislative records. Yes, the Deputy Archivist is also appellate authority for that too. And just like the others, it's 90 calendar days. The difference in this is there isn't another higher authority. This is it. It's whatever the Deputy Archivist says. There is no court. There isn't an ICE cap. You're done. Once she's made that determination, it is finished, so to speak. That's my information. There's also a couple of websites that I've put on here for a little bit additional information about the FOIA that I have found helpful over my career. And I believe that's it.
Well, thank you, Joe, and everybody else on the panel. Really appreciate you guys all being here. Hope everyone in the audience found it helpful. We have some time for questions and answers. And so if you're in this room in the theater with us, we have 2 microphones, and feel free to go up and ask your questions. But I know most of our audience is online and has been streaming and using chat or whatever for questions. And so I'm going to defer to Andrea to see if we have any folks online with questions that she can deliver.
Thank you so much, Gary. Thank you to the entire panel. I've been monitoring the chat this entire time, and it's been very active. As you can imagine, people are very passionate, and I personally appreciate that passion. However, I've been asking for specific questions, and I don't have something really specific. I would just, the closest one I had was, if someone gets a redacted document back, will they learn exactly why? And if you could just, one of you, maybe Martha, might want to cover that briefly, how that happens when you get a redacted document.
Yep. So the way our system works is whenever we make a redaction, we have the redaction code to the side on the piece of paper, like the one I showed you. It will tell you the B provision of the FOIA under which that document was held. And in the correspondence that we send, we will also explain in more plain language exactly the types of information that were held for which provision. So if the letter says that there were 50 pages held for personal privacy under B6, portions redacted, and 20 pages for B7D for sources, when you look at those documents, the redaction will tell you, there will be to the side a little dotted line that will tell you what provision, and then you'll know the reason why. So yes, we do always explain the reason why.
And similarly, if we have something that part of it has to stay national security classified, in our final correspondence to you, we will tell you which agency made that decision to redact.
I appreciate that. That is very helpful to know. It looks like we have a question in our theater. Sir, go ahead.
It was unclear to me on law enforcement records where there are redactions of sources and methods and other things. Do those come to the archives already redacted, or does the archives have access to that information on appeal?
So they come to us fully open. So
Fully of it.
they unredacted. What we receive are the original records, unredacted, and then we read them and make those determinations so that if there are redactions for those reasons, they've been applied by the National Archives.
Are there occasions when the information might be so dated that the source information actually is available?
If we can determine that there has been a valid release, authorized release of that information, we will release it as well. However, it has been upheld in the courts that we continue to protect the identity of sources even after the sources have died for a period of time. So we are following the case law that's largely been established when the records were in the custody of the agency, mostly the FBI. And we will continue to protect sources for a very long time. unless, as I said, there's been an authorized release of that information in the past that we can determine in some way.
Well, I've got some heavily redacted documents from the FBI about matters happening in the 1950s. And I was wondering whether maybe I should seek the similar documents from archives at this point.
So if that case file, for instance, of the FBI has been transferred to the National Archives, to our permanent holdings, we will do a new review. Certainly, if they were holding things for personal privacy, it is likely we will be releasing the personal privacy information, and we'll do an evaluation on the source information as well.
Okay, thank you.
I believe the FBI says they have a 150-year rule for confidential sources, essentially to protect the family members and descendants of some sources, because they will note that some of the, especially in organized crime world, people have very long memories and may exact revenge on descendants of the snitches or whatever, and so that is why they withhold even information on people who are deceased for quite a long time. Because other than that category, generally personal privacy restrictions end upon the death of the person. So there's lots of information that we will withhold and agencies withhold under B6, the B6 exemption for personal privacy, that once the person whose privacy we've been protecting has passed away, then we can open that information, and we will open that information. So that's the general rule on personal privacy, but there's the exception when it comes to confidential sources, whether it's the FBI or even the CIA. So well, you know, I had a couple thoughts and questions, because you heard most of these people, my colleagues on the panel, talk about papers and boxes and materials, and you know, one of the questions we get almost all the time is, why haven't we digitized everything? Why isn't it all, you know, electronic, digitized, and on the web? So what is the answer?
It just takes a really long time to digitize 10 billion items.
Or is it 12 now?
Or is it 12 billion, or however many?
That's right.
I will say, though, that we are routinely digitizing the records that are requested for review to facilitate our review, because our redaction is done through an online system. And so we even changed our staffing pattern to add technicians to our staff who are going through our backlog queue and digitizing entire, for instance, FBI case files that are requested, so that the reviewer is not dealing with paper anymore. They're simply pulling up when it comes to the top of the queue and doing the review that way, and we are largely delivering those records electronically. And then the next challenge is for us to find a way to get them posted in the catalog. So we are, upon request, digitizing the records that are requested for review, but it is really just sheer volume. And also, you have to remember, our records are unique and original, and we have to be very careful how we are digitizing them, because we need to preserve them. So I like to remind folks, we're not Kinko's. And if we can even feed, it has to be very sensitive feeders. Generally, are doing a lot of flatbed scanning. That's very time consuming.
John, did you have further comments?
No, I just want to basically build off what Martha said. Certainly for the libraries as they can, and Don's shop as well, you know, we're all committed to that goal of digitization. It really just does come down to resources. There are sometimes aggressive. We get partners, outside partners, that help fund our digitization across the board. And we're able to more aggressively digitize in certain areas. But it does come down to the balancing the protection of the records and then having the resources to do it. But we certainly understand that is the direction of this agency, and it's what we want to do. It is making access happen, and it makes access happen for everyone, and they can get the records as soon as possible.
Yeah, and you know, and some of you may have heard, even in NARA's strategic goals, moving forward, we're trying to get to the point where all records are electronic and all agencies are creating and preserving all of their records electronically. But that's their current records, and going forward, and as Martha mentioned, especially with federal agency records, we have a lag time. We generally don't, the permanent records that they have don't come to us until they're anywhere from 15 to 30 years old, and sometimes even older. And so we won't be getting those electronic records for a couple more decades, and we have still the tail of paper records coming in. I believe it's still roughly another 3 million cubic feet. So we're talking about another 8 to 10 billion pages of paper that are still due to come into the National Archives over the course of the next 20 and 30 years before the transition really, fully takes place and everything we start getting is electronic. So we are in this bipolar world of paper and electronic, and we have to deal with both.
And one thing to add on to that, because on the presidential side we receive records at the end of the administration, so they're coming in, we are seeing the trends already that will certainly dominate the federal records, the agency and department records in the years and decades to come. For example, Clinton was the high mark of creating presidential records in textual form. But also unique with Clinton, it was the first large accession of electronic records, taking in about 20 million emails as well as other electronic files. With Bush 43, also in office 8 years, you saw a slight decline in the volume of textual records, but a giant increase in electronic, and that continued through Obama. And we consider that while there will always be a certain amount of business done on a paper basis in any organization, we're clearly seeing this trend of smaller and smaller textual collections coming in at the end of a presidential administration while the electronic records continue to grow.
And thank you. Appreciate the answers. I have a couple of questions that have come from online, sort of a two-part question. I'll start with the second part, and this is for you, John. He says it's in relation to the Presidential Libraries Act, and I know we're talking about federal and presidential, but this person is asking about the release of state government records or the release of presidential records in the state. So release of presidential records in the state.
So and Gary may want to jump in here, but I'll try to give an answer. The records that come into the National Archives, whether on the federal side or the presidential side, say if they're generated by the state, at the point they're received by us, that copy is federal record or presidential record or congressional record and is governed, access to that is governed. Now, anything that remains with the state, their operations, et cetera, is governed by their unique access restrictions. Some states have their own version of FOIA. Some do not, but it varies quite widely amongst 50 states. But to gain access to that material is very much at the state level. We hold federal records, but if I'm understanding the question, at the point those state records actually come into us, we would treat them under our access provisions.
And yeah, just to supplement, I think it's when a state interacts with the federal government and they send information to the federal government, then what's received by a federal agency or the White House becomes the record of the agency in the White House, and then those are what we might have. But when states and localities create and receive their own records, then those don't come into the National Archives. Whatever they have is subject to state law.
I appreciate that, and you did answer the question completely. And I have another question, and this is a great question. I wish I could take ownership for it, but it came from an online viewer. And she asks, if each of the presenters could wave a magic wand and correct a common error in a FOIA request, what error would they most like to correct? Great question. So
a
someone's
good
putting in a FOIA request and there's a mistake in there and it's really common, and really like to, if we could correct that one mistake.
I'll jump in while people think. It builds off what Martha was saying, specificity. I think that for us, there is a tendency at times among researchers to not rely on the expertise we have. As archivists, our goal truly is to make records available to the public. They may have had experiences filing FOIAs with other agencies whose core goal is not to make records available to public. This is what we do. This is our passion. And working with us as soon as possible, talking to us, trusting our judgment, I think is one of the ways that you can gain access to the material you want as soon as possible, instead of maybe a broad approach, everything you have on something, which we've all received those FOIAs, and it really bogs down the process, and not only for that person getting it, but everyone after them.
And I'll jump in next. I think if I could wave my magic wand, it would be to wave it over some of our agency partners, because I'm sending out on consultation, and John's folks do too, records that are historical. They're 25, 30, 40 years old. And sometimes our friends in the agencies are reviewing the records in their FOIA shop with a today lens. They're not using historical perspective to realize that a document relating to Vietnam is going to be reviewed under a different standard than a document relating to a 2017 operation in Afghanistan. So if I could wave my wand, it would be to grant the gift of historical perspective to our agency partners.
Very good.
I think the only thing I can think of, actually, again, speaking to federal agencies, not to beat up on our wonderful partners in the federal agencies, but the National Archives runs a record center system where we help agencies by storing their records that they don't need anymore, but that are not yet ready to be disposed of or sent to the National Archives. And fairly often, agency FOIA folks think that when those records are at the Record Center, the National Archives handles the FOIAs for them. That is not the case. Those are still in the legal custody of the agencies. And so I find it frustrating when a researcher comes to me and says, so-and-so agency said that you have these records. We finally figure out that they're at the Record Center, and I hate having to send people back to where they started from. It makes them angry. I understand why it does. But some of the FOIA staffs, even though I do work a lot with agencies, and I kind of repeat this over and over again, if it's in the Record Center, it's still in their legal custody. And so researchers need to file the FOIA with the originating agency until that legal custody is transferred to the National Archives. And it's kind of esoteric, but it happens every week. So that's my wand.
Thank you. Mine's an easy one. Just backspace through and get rid of FOIA altogether.
Wow, I get paid because of that, so no. But on the appellate side, what I would like to see is researchers understand the difference between research and search under the FOIA. There's way too many times in which I do believe that the public believes that we all just sit on our hands and aren't willing to conduct. We're not going to do research for you. We can't. We're not staffed to do that. But we are, under the FOIA, required to do a search. But because of the sheer volume of records that Gary mentioned at the very beginning of this talk, we can only conduct their staffs can only conduct so much time for every request. We hold to that very closely. So it'd be nice to see people understand that we can search for the records and then inform you about it. We can't research for you.
And also under FOIA, we don't answer. FOIA only requires us to produce records, does not require us to answer questions. Often, very often, FOIA requesters will pose questions and want us to answer them. And we're not required under FOIA, and that's a kind of whole different approach. And so if it's a FOIA request, you got to just ask for records. And then the only other thing I would add is if you are making a request that is for a high volume of records or a large or records that are complex, full of lots of sensitive information, those are the ones where we're almost certainly not going to be able to answer in 20 working days as the law requires, and we request your patience. We do have queues, and the law requires we essentially operate on first in, first out, and unfortunately in some of our queues, it's they're essentially several years long, and there's nothing, given our limited staff, the high volume of requests, you got to wait your turn, and we understand that's frustrating to the requester. It's frustrating us. We wish we could do more and have more resources to get more records out, but we ask for your patience when it's a complicated request.
Okay. Thank you for everything, and your validating that with the search versus research. I think we'll incorporate that into more Know Your Records. I do have a question online, and it's about actual safeguarding medical information, HIPAA. The person, so for HIPAA, I actually spelled it out, the Health Insurance Portability and Accountability Act of 1996. And the person asked, does HIPAA precede FOIA or vice versa? I'm sorry I don't have an example from this person. I'm not sure how that might pertain to a federal record, maybe a veteran or...
So I'll try to answer that. You know, HIPAA does apply to protecting the privacy of medical information for patients. Of course, several federal agencies have such information, the VA, in particular the CDC, and probably the military services as well. And so they have an obligation to protect that information under HIPAA. To the extent that those records are also subject to FOIA, that's what the B6 privacy exemption is meant to protect. In fact, the language of that exemption specifically refers to medical files. And so it's probably the highest concern that the Congress had in passing the FOIA is protecting medical information of individuals, whether they're federal employees or, you know, or veterans and other citizens getting medical care by the government. So absolutely, the government, including the National Archives, protects that information and takes that responsibility seriously. But it's not, they sort of operate in parallel, I believe, and not, one doesn't supersede the other.
Thank you. I don't have any more questions online, and no one's standing at the microphones. Is there any last thoughts from our panelists?
No, we just appreciate everyone's interest, and feel free to file your FOIA request, and we'll try to help you as best we can.
Thank you.
Thank you so much. Thank you, everybody, for coming. Thank you, panelists. And just wanted to let you know that this was video recorded, and it will remain on YouTube, and along with other videos, and we have a growing list of videos available. The presentation slides are there. And you'll also find our evaluation form. I hope that you'll fill that out for us, please. We really do value your opinion. So on behalf of the National Archives and our panelists, thank you for joining us. This concludes today's program. Thank you. Thank you so much.